Well, I said there would not be a Chille video for a while, but now I got a copy of the brief that he filed or his lawyer filed. I want you to see this brief. Now, I'm not saying there's malpractice. I'm not saying he did a bad job. So please, I'm just getting that out there. I also want to show you the rules for appellate procedure in Nevada. And again, I'm a California lawyer, not a Nevada lawyer. So I'm not giving Nevada legal advice, just my perception as a lawyer that handles appeals and First Amendment issues. By the way, one of the comments in my video yesterday was, he's not a First Amendment lawyer. Yeah, defamation is First Amendment. So please understand that. When you defame somebody, you're making speech. And when you make speech, it is First Amendment. Okay, whatever. So let's take a look at this. This is the rule for criminal procedure appeals. 3C is the fast track rule. Now, here are some of the rules that are required when you do a fast track appeal. It's limited to 16 pages in length. Wow. Well, what I saw was 31 pages. It also has a like it does here in California, it has a limit on word count because this is the way to prevent people from filing 31-page briefs. It looks to me that this is a non-compliant brief for several reasons. Example, how does this court have jurisdiction? Because if they don't have jurisdiction, they can't render a decision. And so you would say the court has jurisdiction under Nevada rule such and such because this is an appeal of a criminal conviction in the justice court. Bang, one sentence. The statement of the case and procedural history. So they want a concise review of what happened in the case. And then a concise statement summarizing all facts material to consideration of issues on appeal. You better not miss something. So here I noticed that the appellate brief was 31 pages. I calculated the filing deadline and it was right. This is missing. I didn't see that specifically as a heading with that question answered. An outline of the alleged errors of the district court, or in this case, it would be the justice court because you're appealing to the district court. I didn't see that. And then a statement describing how the alleged issues on appeal were preserved during trial. This is the invited error or waiver that we see here in California, which obviously I think is going to apply in Nevada as well. You know, if you don't object to something, then it's usually waived. There are, of course, always limited exceptions to the failure to object. But the bottom line is that when you see a judge sitting on the bench, the judge is an umpire, but in baseball, the umpire calls balls and strikes automatically. In a trial, that's not how it happens. The umpire only makes a decision when you ask the umpire to make a decision. I took his brief and then I converted it into Word so I could type on it and then converted it back to PDF. So, of course, it doesn't really look like this. Ways of communicating that are effective and ineffective. And you can't always avoid these. You just don't want to rely on them too much. Passive voice usually puts people to sleep. Starts to sound robotic, and robots do not persuade. Was, had, have, would. Those words, you know, sometimes you just can't avoid using them. They're the most direct way to say something, but you tend to want to avoid using them too much. The verb was cited, see, I used it 84 times, had, have, would. And then I noticed there's a curious sentence structure that keeps repeating itself. And the more that the sentence structure resumes a cadence, the less persuasive it becomes. Glick, but it's not from this circuit, which I find puzzling. You want Ninth Circuit authority, not First Circuit. Clearly is a word that you want to avoid using except in very obvious situations, because clearly is telling the judge or the justice how to think. More persuasive arguments include suggestions about what the outcome should be. And some of this didn't come out too well because it got converted over on top of converted. But I don't like capitalized words in the middle of sentences because it starts to look like a ransom note a la Dirty Harry. And procedural history was required. If you this is what I just briefly wrote in a matter of minutes, but this brief has a wind-up. I don't like wind-ups. You know, if you ask somebody what happened and they start from the beginning, and by the time they get to the end, you're kind of wondering what it was they were talking about. Appellant Jose DeCastro was charged with 2, and he likes to do this. He puts the number right after the in parentheses. He'll do that repeatedly. You don't need to do that. And it says obstructing a public law. These things would be in quotations while filming a traffic stop. It says Mr. DeCastro appeared for an arraignment. Trial began. Judgment was entered the same day. And then again, it's the same day. So I don't know why he has to repeat the date. 180, again, the number in parentheses. Following sentencing on March 19, he filed a timely notice of appeal without really saying the actual date of filing the appeal. So I just decided, rather than this long warm-up, I want to give somebody an overview. If you got a 31-page brief, tell them what they're about to look at. Now, this is just very minimal. I would have added more to this, including what are the major issues on appeal, which is required under the appellate rules. So again, this is just a first draft for me. Jose DeCastro, appellant or DeCastro, was convicted on March 19th of 2 misdemeanors in the sections before Honorable Judge E. Zimmerman in Department 8 of the Clark County Justice Course. Appellant, a prolific YouTuber who films police officers in search of potential human rights violations, was tried without a jury. Judge Zimmerman, who sought input from the district attorney regarding sentencing, ignored the people's suggestion of a suspended 90-day jail sentence and instead sentenced the appellant to consecutive terms of 90 days each. Both Judge Zimmerman and Judge Michelle Levitt denied appellant's motions for release on bail pending the outcome of the appeal. In appealing the convictions, jurisdiction arises under Rules 3CA of the Nevada Rules of Appellate Procedure. The rules, lawyers like using defined terms. The appellant brings this fast-track appeal under Rule 3CE. A notice of appeal was filed on March 26, and the opening brief was timely filed on May 6, pursuant to Rule 26. Trial lasted less than a few hours. Only the appellant and police officer Brandon Bork testified. Aside from live testimony, the lone exhibit admitted into evidence consisted of a truncated videotape of body cam footage lasting approximately 12 minutes. Now, you can add to that, obviously, but wouldn't you really know what's going on if you're the justice looking at this? Oh, okay, got it. Now your brain is starting to wrap around what is about to happen. Then I would follow with the statement of issues on appeal. So here's the historic stuff on this. He's been employed with approximately eight years. So what? At approximately conducted a vehicle stop on a Hyundai. Vehicle was pulled over in a Target. I like how Target is not capitalized. Officer Bork was dressed in his uniform and was driving a clearly marked black and white Las Vegas Metropolitan official vehicle. How about just saying Officer Bork was in a squad car when he approached DeCastro? You don't have to say was, but you get the idea. Look how many words you just saved. Then he writes this. The sole occupant of the vehicle was a female who was cooperative and provided a picture of her license on her phone. Well, he just transitioned from this to this. So is he saying that Officer Bork was a female? Officer Bork was dressed in his uniform and was driving. Now it switches to a female from his, but says the sole occupant of the vehicle was a female. This really belongs up here. He's talking about the vehicle that was pulled over. That's kind of funny if you ask me. During the vehicle stop, Mr. DeCastro, a member of the press. Now, this again, they love to emphasize this press thing. Okay, fine. He owns a YouTube channel. I don't think he owns it because I don't think you own anything on YouTube, but you might have a license to use it. Police activities because he believes police misconduct is an epidemic in the country. Right. Then you'll see that a lot of this stuff begins with his name or the other person's name, and it becomes more of a cadence, the number followed by the number in parentheses. However, I call these sentence interrupters. There's also, I think, lack of punctuation here. Normally there would be a colon and then it would explain it. Unfortunately, trial counsel, now I think it pained Orem to mention Michael Mee by name. In fact, he doesn't mention him by name at all, and then uses a footnote to say, I'm not trial counsel. And it gets even more hilarious because if you look at the notice of appeal that was filed, Michael Mee's name is on it. So I think they have something to answer for. He admitted that Mr. Castro backed up, but he did not substantially back up. However, he also said he did not back up. The video demonstrates that the officer is clearly wrong. See, this is a conclusion that needs to be elaborated more. And this is a false statement, I think. DeCastro asked the driver if she was okay. He did say that and did not make any further comments. But he did. He mentioned, I remember seeing that he talked to her twice. To back up on several occasions, but never stated how far. That's true. Claiming he had no opportunity because that's true. Obviously, see, you want to avoid these obviously, clearly. The officer admitted he observed no weapons on Mr. DeCastro, holding two cell phones. He says, go get in your car, little doggy. But he leaves out the part, I think DeCastro said something like, why don't you write your effing ticket? Go back in your car and write your effing ticket. That's significant. If I was the people, I would play up on that. Say, wait a minute, why are you leaving that part out? You don't want to make him look too vile. There's also repetitive error here in the quotation and the period. I don't do that. You usually see two space separation between the periods. Having decided to let the motorist go, instead concentrate, blah, blah. Why would you say that the officer had irrational fear when he said on the stand and he wasn't afraid of anything? In fact, he said that DeCastro wasn't a threat. Why would you put that in there? Doesn't that kind of contradict what the cop said? His testimony concerning officers' safety belied. You don't want to use words like belied. Try to keep the words simple. Then it says, the officer is clearly agitated and frustrated and does not appear fearful in any manner. Yeah, he's aggressive, as depicted in the video. And again, these pronoun references are problematic. I mean, you can figure it out, but it's not really clear writing because you're mentioning DeCastro and the cop, and then you say he. How about just cutting this down? You could say something like, the officer testified at trial he was not fearful of DeCastro. The officer testified to technique utilized in the police academy where an attacker can reach a police officer within 21 feet under certain circumstances. That's right, the 21-foot rule. Now, I also know of a 21-foot rule. If you had 21, I can't help myself, foot-long subways, you've got the 21-foot rule. There's the therefore again. The officer concluded that he has some type of imaginary legal rule. See, that kind of language does not fit very well in appellate briefs because it's sarcastic. This was presented as a valid piece of evidence by the state without regard to any legal authority. Well, it got admitted into evidence, so you need to talk about that. Arbitrary and capricious is an unconstitutionality standard. Be careful when you say that. You better really know what you're talking about. Additionally, officer seems confused as motives for the arrest. If you're saying it seems confused, then you're not saying anything with authority, which means the tie goes to the runner, as can be easily depicted. And then there's easily again. And now he goes into George Floyd, which is from a different district. And now I get the perception, this is just me, I don't have any proof of this. This sounds like something Chille wanted Orem to put into the brief. I think it's completely out of bounds. First of all, wrong district. Secondly, nobody died. And in fact, the whole premise of what Chille was saying at trial was, what's the big deal? You know, what did I really do other than piss off a cop and try to film? That's what he's saying. But now he's trying to compare it to some civil rights abuse where someone died. See, you got to be careful not to cloud the record with stuff that makes the judges wonder, wait, what am I missing here? Why are we even talking about this? Would the state of Nevada prefer that the state of Minnesota and the federal government prosecute the filmers of George Floyd, and perhaps suppress the evidence? This would be what we call a rhetorical question. I have never seen the state of Nevada ever question the state of Minnesota, and I've never seen the federal authorities also be joined in questioning by the state of Nevada. And this really doesn't, this is a bad analogy. Okay, maybe, I don't know. I feel like this was Chille's part in this brief. Neither the federal government or the state had any ridiculous notion. See, again, this is inflammatory language, and it doesn't usually work very well in appeals. Additionally, so kind of sounds kind of too informal for an appellate brief, did not capture police brutality against the motorist, he must be guilty. Although in federal court, Mr. DeCastro will be able to bring a federal lawsuit against the officer for his brutal treatment when Officer Bork grabbed Mr. DeCastro during the unlawful arrest and violation of the first, fourth, and 14 minutes. I can't even say this without running out of breath. You need to break the sentences down. They need to be clear. And this just sounds like an argumentative statement that is, again, not something I would put in an appellate brief. We have another sentence interrupter. Alternatively, if he had captured police brutality towards the motorist and it was covered all over the mainstream press, Mr. Castro would be named a hero. I think you'd probably put that in quotes. It would not have been found guilty of the allegations. I don't know that that's true because, remember, you're trying to overcome the standard of proof, which is beyond a reasonable doubt. The highest standard we have, even higher than clear and convincing evidence. This is not doing this. It never seemed to occur to defense counsel, the prosecutor, nor the trial court. When you start taking pot shots at a trial judge, be careful, because the general rule would be is that when you're chopping up a judge and showing this disrespect, the appellate courts could say, they could recoil on that, and they would say, you must not have any other real arguments here. If all you want to do, if one of the things you want to do is basically besmirch the reputation of the judge. You have to take it in a very tactful and respectful way. And if you say it never seemed to occur, and I don't like starting with indefinite pronouns, it never seemed to occur, would have caused prosecution of the bystanders filming during the murder of Mr. Floyd. I can tell you for a fact that I don't think that that ever came up as something that anyone was even thinking about, because the parallel is ridiculous, to use the word that he used in the brief. So we have another it and another it, and it seemed to go over everyone's head. That's going to be underlined by a justice or a judge that's reading this appellate brief. It's going to be underlined. Here we get to additionally, a question of concern must be addressed. Well, why wouldn't you address it? Why would you need to label it that way? If Mr. DeCastro was an African-American and the driver of the vehicle was an African-American female, would the state have prosecuted this case? Oh, okay. So now we're going to take this from this simple traffic stop to now turning it into a parallel to a murder case and racism. Last I checked, nothing discussed about racism in the trial. So now you're not citing to anything that's in the record of the trial. And the rules generally prohibit that. You want it to be clear and focused. Hey, the statutes say this. It's so unfocused. And I think that Chille is behind this. I don't think that Orrin would have put this stuff in there. DeCastro's evictions must be reversed based on violations of the First Amendment. Okay, we're finally at page 10 getting to it. The issue before this court is whether DeCastro had a constitutional right pursuant to film. Of course he has that right. That's not really framing the question. While the police officer is conducting a minor trap, of course they do. You could film the cops. No one said you couldn't. The cop admitted that. So why are you saying that's the issue? Even the judge said that's not the issue. To affirm these convictions, this court would have to determine Mr. DeCastro, a member of the press, member of the public. When is the press not a member of the public? Does not have the right to film a police officer conducting his ordinary daily duties. This statement makes no sense to me. This legal rationale would violate clearly and historically established. Of course, there's no citations to the cases that say this. This is just argument. Remember, argument is not evidence. The court has provided important dicta. Dicta means that that's not what the case was about. I can't remember even citing to one law review article, because most law review articles, it's like, so what? And right now you need to persuade her that beyond a reasonable doubt, this conviction needs to be overturned, or there's such a serious error that it affected the outcome. That's where her mind is right now. In fact, and nope, you could eliminate these words. At no point in the trial or pre-trial proceedings, you could just say at no time during the history of this case was a single legal authority cited regarding the most fundamental rights guaranteed to the public and the press under the First Amendment. Great. I'm glad you just said that. Now, is this invited error? And here we go to Glick, a case that is in the First Circuit, not the Ninth Circuit. That's a big problem, because you need to find the cases that are within our district, not somewhere else, unless there are no cases in our district. And then they cited Glick forever and ever. They've been into a lot of trouble to cite to Glick. And again, these would normally be quotation marks. This part's a little bit hilarious here. This is the internal pagination reference to the case itself, because you need to take that part out. They're actually referring to both counts, so it would be counts 1 and 2. These are all conclusory statements. I would have expected a much more in-depth analysis. Once again, no Nevada authority. This is going to be a tough argument. You notice nowhere in here he's referring to DeCastro as a constitutional law scholar. He said that on the stand. Now, I've been saying that once you decide to give yourself that name, you have opened the door to a heightened level of awareness and knowledge of the laws. So interestingly, they've decided to do away with the constitutional law scholar designation, because I think they realize that it's a problem for him. Vague and ambiguous. Well, it is obvious that there is no 21-foot rule, again, with the quotations in the period. Obviously, there's more obviously, walk within 21 feet of the police and their vehicle, but I think this is misstating what the cop said. He didn't say it's always 21 feet. Yeah, he never attempted to physically interfere, but under the Wilson decision, you don't have to physically interfere to be busted for obstruction. His state and federal constitutional rights when his trial was presided over by a judge with prejudice. This is really, no way. This to me is just not the right approach. I rarely see appellate briefs that tear into a judge like this. You could say that the judge got it wrong in a very diplomatic way. You could say the court failed to apply this reasoning. You don't mention the judge by name. You say the court, the factors the court weighed should have included this. People are fine with that. But now you're saying that the judge was prejudiced. Well, you never argued that she was prejudicial towards you during the trial. You didn't argue that during the pretrial hearings. You didn't move to disqualify the judge. It's called a 170.6 out here in California. So now what? You wait till you get the verdict, the decision you don't like, and now you claim it? I like the extra period here. That helps emphasize that you need to stop your thought again. The trial court then orders Mr. DeCastro to empty all his pockets. Walk right into a courtroom. You have already surrendered those rights. It says here that the trial court noted in reference to her marshal as a pig. She did, but Zimmerman did not say that was the reason for the sentence. It was the videotape. Remember, Orem was at the bail motion hearing where she said that. So this is a little bit misleading, if you ask me. It's not really that accurate. The legal standard actual bias, unless it's got copied wrong when I converted it, once again, it's not a complete sentence. She didn't have any stake in the outcome or become embroiled in the battle. Well, if you're going to say she's embroiled in the battle, actually, she did not cite him in contempt and gave him mid-range sentences. The trial court should have disqualified herself based upon implied bias. I don't think that that's bias at all. If you want to mouth off to a judge, if I did, I would be facing the same predicament. So now you're getting into the situation that I really don't like as well. Now you've got Michael Me, and now you're throwing him under the bus. The problem is that I don't know the reasons for it. This isn't the guy's first rodeo, and he's got a lot of significant wins. Let me just say this. If I had a client, and I've had them, who dictates to me how I'm supposed to do my job, I'm going to make mistakes. If you're overbearing, you're now making me think I've got to run things past you, and stuff is moving fast. While he's talking about an exhibit, and I'm thinking about what rule could exclude that exhibit, you're in my ear complaining about the fact that he's a liar. Difficult. I saw Michael Me's body language. He was uncomfortable. His arms were crossed. He just, you're going to say these things. I had a client that did that to me in one of my cases. You're going to bring all this stuff up. And he got mad at me because I didn't want to. It had no relevance. And I was scoring points with the judge. Once I brought it up, the judge said to me, "Where are you going with this, counsel?" The only thing that was evidence that I saw was the videotape. And I mentioned that the videotape could come in just from the sheer testimony of the parties identifying what was happening. This is, I think, a real stretch. What he's saying here is that had Michael Me submitted this briefing to the judge before the trial or at a separate hearing or had a separate motion for it, it would have been sufficient to blow out these two claims, almost like summary judgment in a civil case. That's not really true in my book, because I'm reading what you're writing here in this appellate brief, and I haven't been persuaded that you've moved the needle much at all here. I don't think this brief is winning. I kind of selected it in red when I copied it over. Unconstitutionally vague and ambiguous. They have the burden here, and I'm not seeing it, not as it's been presented here.